Welcome, everybody. Objection to form, I yelled during trial. Please stand by. Hello, everybody. Hello, everybody on Facebook and on YouTube. Come join me for a few moments as I share with you some terrific information. But before I do that, we're going to have our corny ticker tape go by. What is it? Objection to form, I yelled during trial. Please stand by. For those of you who've been watching before, you know that I have this corny ticker that goes by. Why? Because this way it shows you exactly what it is I'll be talking about, as well as it gives people an opportunity to come join me as we stand by and get ready to get started. Hello, everybody. Hi, everyone on Facebook that's watching. Excellent. Thank you for joining me today. What a beautiful day today. Alan, nice to see you. Thanks so much for joining us. Today we're talking about objection to form, I yell out during trial as we go by. So hang on a few moments while we get ready to get started, and I show you my fancy ticker tape, better than any graphics you will find on TV, whether it's CNN, MSNBC, Fox News, or any other station around, because this is homemade. It's creative. It's simple. Kevin, nice to see you. I love this. My ticker strategy, brilliant. That's right. Kevin, you're the one who taught me about being simple and having the most basic things, getting back to basics. And so thank you for joining me. This is wonderful. This is exactly what I did. I don't need fancy graphics. All I have right here is a piece of paper that I printed out showing you exactly my title. Thanks so much for joining me. I really appreciate it. All right, it's a beautiful day today here in Great Neck, and I wanted to share this great information with you about objections that occur during trial, and it doesn't matter what kind of trial it is. It might be a civil trial. It might be a criminal trial. You're going to hear objections if you're a litigant, if you're a person who's participating in the lawsuit, or if you are an observer in the back of the courtroom. You're going to hear about these different basic objections, and I'm going to share them with you so that by the end of our quick conversation today, you're going to understand exactly what these objections really mean. So thank you so much for joining me on this beautiful Sunday today. And again, what are we talking about today? We're talking about objection to form, I yell during trial. Please stand by. Now, we're almost ready to get started, and this hopefully provides you with some quick level of entertainment, something basic, while we're actually waiting for more people to join us. And if not, they're missing out on some great information. All right, so now we're ready to get started. Well, hello, everybody. I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And by now, you already know what it is that I'm talking about. We're talking about objections to form and other objections that show up. Thanks so much for that thumbs up. Other objections you're going to hear in any lawsuit, any trial that occurs, whether civil or criminal. And it doesn't matter whether you're watching Law and Order on TV or you're watching a courtroom drama in the movies. You're going to hear an attorney jump up out of a seat and say, "Objection, Judge! I object to that! I object to the form of the question." What does that really mean? What does that mean? I'm going to tell you right now what it means. It means that the lawyer who's asking the question didn't do it very well. He didn't ask an artfully worded question. It's somehow jumbled, it's somehow complex, and now he wants to make it simpler for the jury to understand. So I'll give you a great example. Let's say it's a car accident case, and now you claim that there was a careless driver that caused you significant harm and injury, right? So now the defense lawyer, representing the person whom you have sued, is up cross-examining you. And now he asks you a series of questions, and one question he asks you is, "Hey, Mrs. Jones, were you speeding at the time you went through the red light?" And your attorney jumps up and says, "Objection, Judge! Objection to form!" Now, what does that mean? It means that the attorney has asked a badly worded question. Now, why is it a badly worded question? Well, in this instance, in this example, he's asked what we call a compound question. He's made a number of assumptions. Number one, he's asked you whether you were speeding. And number two, he's asked you whether you went through the red light. So if you were to answer yes, how do we know what the yes is an answer to? Is it to the speeding? Is it to the red light? Is it to both? We don't know. So the reality is, the problem is, because it's a poorly worded question, your answer is going to confuse the jury. Your answer is going to confuse an appellate court if your attorney has to appeal the case. And now the higher court is now looking at the transcript to determine exactly what the question was and what the answer was. You'll find that the best attorneys in New York and elsewhere, when they're cross-examining a witness, they will ask one question per fact. "Mrs. Jones, isn't it true that you were speeding at the time of the impact? Yes or no? Mrs. Jones, isn't it true that the light was red for the direction you were traveling? It's either yes or no." So now when you give an answer, the jury clearly understands what the answer is to. It's to the speeding, or it's to the red light question. But when the attorney asks a question to which is not properly worded, it's a badly worded question. And by the way, even the best attorneys will sometimes get, crazy scrambled words in their mind, and now it comes out really terribly. So now the judge will have no choice but to say, objection sustained. And what does that mean? When the judge says objection sustained, yes, thank you so much for the thumbs up, it means, hey, counselor, you can't ask that question. That's not the correctly worded, that's not a good worded question. Ask it a different way. The judge isn't saying that you can't ask about what occurred, or about the red light, or about the speeding. He's just saying you didn't ask it right. And it also means that the witness is not to answer the question. Thank you so much. Alan, thank you so much. That's great. Kevin, that's great. I love that. Okay? And I'm so glad that you're with me, because these objections are so common, and we hear about them all the time on TV and in the movies and in the court. So that's objection number one. So what's another objection that we frequently hear over and over again? Well, another objection that we typically hear is, objection, judge, not relevant. Now, what does that mean? Well, you and I think we know what it means, right? Okay, something isn't relevant to the issues in the case. Let me give you a great example. Let's say this is a medical malpractice case, and you brought a lawsuit against your doctor claiming that, number one, he was careless, number two, that his carelessness was a cause of your injury, and number three, that your injury is significant or permanent. So you got three different reasons to bring a claim against your doctor. All right, so now, what happens next? You should know that in New York, we can't just go forward with a lawsuit just because you think a doctor did something wrong. Instead, we have to get confirmation from a medical expert, a board-certified medical expert, who actually says, yes, Mrs. Jones, the doctor was careless. Yes, his carelessness was a cause of your injury, and yes, your injuries are obviously significant or permanent. So only then can we go forward with a case. But the doctor turns around and says, hey, wait a second, why are you suing me? I did nothing wrong. Nothing I did caused or contributed to your injuries. And by the way, even if I did, your injuries really are not as bad as you claim them to be. Those are typical defenses we see in these malpractice cases. So what happens next? How does this other objection about relevance come up? Well, when you have this type of malpractice case against your doctor, now in all likelihood, when it's hotly contested, all the issues, your case is going to go to trial. And let me take an unsponsored water break right here. Today's water is Poland Spring. All right, so now your case is going to go the distance, and it might be 2 to 3 years from the time that you start your case until the time you get to trial. Now you're at trial, and guess what? We put on our medical experts to support our claim, to show that you are more likely right than wrong, that you are justified in getting a verdict in your favor. And now the defense lawyer has an opportunity to cross-examine, to question our medical experts, to test his credibility, to test the truth of what the doctor is saying. So now get this. This is a great extreme example. So now what happens? The doctor's on the witness stand, right? And now the defense lawyer gets up to question him. And now he's asking questions that apparently relate to the case. And out of the blue, he says, doctor, isn't it true that you beat your wife each and every night? And your attorney's like, what? Why? He jumps up out of his seat and yells out, objection, judge, relevance. That's when that type of objection comes up. Now, what does that mean? Well, I'll tell you what it means. It is so outrageous and so outlandish to ask a question like that, that number one, the attorney better have a good faith basis to ask such a question. And in all likelihood, he's not going to have great information on that or have a good faith basis to ask such a question. Number two, you have to go ahead and be able to show that that is somehow relevant to the doctor's testimony that he's giving in your case. And in all likelihood, it's not going to be relevant at all. Now, does it have anything to do with the claims that you are making? No. Does it have anything to do with the defenses that the doctor has raised in your claim against him? The answer most likely is no. But, now here's the but. The but is that it may have something to do with collateral issues. It may have something to do with the doctor's credibility. Now, why is that important, you ask? It's critically important because in a lawsuit where you are trying to seek money as a form of compensation, I want to share something really, really important, and pay attention to this. This is critical. You will find that there is something in every lawsuit where the facts don't matter, where the law doesn't matter. And you're probably thinking, wait a second, what the hell is Oginski saying? The facts don't matter and the law doesn't matter. It's true, because there's something in law, in these civil lawsuits, that is much more important than the facts and much more important than any law the jury's going to hear about. You want to know what it is? It's credibility. Your credibility. The witness's credibility. How believable are they? That's an intangible thing that we cannot put a price on. If the jury determines that you are credible, now they go to the facts, now they go to the law, and then they determine whether or not you're entitled to a verdict in your favor. If, however, you have destroyed your credibility, if an attorney has destroyed a witness's credibility, now the jury is fully entitled to say, hey, witness, we don't believe a word you've said. We don't believe you're entitled to a verdict in your favor because these witnesses, hey, David, nice to see you, because these witnesses are not believable. So your credibility is so critically important. So that's what I said. That's what I meant when I said, listen, if the defense lawyer now has a good faith basis to ask about this doctor's beating, domestic abuse of his wife, of his spouse, now it may go to the doctor's credibility that the jury might be entitled to hear about. And if the defense lawyer can convince the judge that, yes, his credibility is critically important and this issue plays a great role in his credibility, then there is the possibility that the judge will allow the attorney to ask the question and require the doctor to go ahead and answer that question. So the judge is the final arbiter to decide whether or not this issue is relevant. So now let me turn it around a little bit. In the same example, instead of asking about whether he beats his wife every night, which, by the way, assumes two things. Number one, that he beats his wife, and number two, he does it at night. So there's a problem with the question, the form of the question, as well as whether or not it's relevant. Let's say the question instead of beating his wife now is, hey, doctor, did you pay taxes? Or did you file tax returns for the last 3 years? Now, that's a different issue that, again, can affect his credibility. The judge in that instance would likely allow the attorney to ask that question and require the doctor to answer it. Because if he did not pay taxes or file taxes within that period of time, now that might affect his credibility and might impact the jury's ability to decide whether or not this guy should be believed about the actual facts of your particular case. So you see, it plays a very interesting role in whether or not these questions are relevant to the claims being made or to the defenses the doctor is raising. Very, very important distinction. And I'm going to take another unsponsored water break. Again, if you'd like to sponsor this video or other videos in the future, reach out to me. I'm happy to talk. All right. We've now talked about two different objections, common objections that we see at trial. And the first one was objection to form that I yell out during trial, or another attorney because he doesn't like the way the question is worded. So this was the first objection I talked about. The second was relevance. Objection, Judge, that's not relevant. And now the judge has to decide whether or not this particular topic is relevant. And if it is, he's going to say objection overruled, which simply means that the witness can go ahead and answer that question. All right. So now let's get to objection number 3 that we commonly or typically hear during the course of a trial. And here it comes. Objection, Judge, that's hearsay. And now I'm creating the emphasis, I'm yelling out. You will notice that when you go into trial, when you go into any trial, when an attorney makes an objection, he typically will jump up out of his seat and now in a loud voice say, objection, Judge. Why does he do that? He does it for two important reasons. Number one, he has to capture the judge's attention. Number two, he has to be respectful to the court, so he's standing up every time he speaks to the judge. And by the way, there is a third reason. The third reason is, thank you so much for the thumbs up. Hey, Ronnie, nice to see you. There is a third reason. And the third reason is that he doesn't want to give the witness an opportunity to go ahead and answer that question. So he's got to stand up and make himself known that there's a problem with the question. And those are key reasons why an attorney will jump up out of their seat, go ahead and yell out objection in a voice really loud, and now everybody's attention is diverted away from the attorney asking the question. They want to know, what's the problem? I just heard a question. Now the attorney's objecting. What's the big deal? All right. So this third objection I'm talking about today is objection, hearsay. Now what is hearsay? Oh, I hear what he said. No, that's not what it means. That has nothing to do with it. Has nothing to do with, oh, I hear what he said or I hear what he's saying. No, no, no. So let's say, again, this is a medical malpractice case. And now, again, you've brought a lawsuit against your doctor claiming that he was careless. But you want to tell that you're on the witness stand, right? And now you're being cross-examined by your attorney. No, let me go back. Let's say you're being questioned by your own attorney. Hey, Steve, nice to see you. Thanks for joining me today on a beautiful Sunday. So, again, we're talking about objection to form and other common objections that you will find during the course of a trial, in any trial, civil or criminal. And that occurs in malpractice cases, accident cases, wrongful death cases, criminal cases, whether you see it on TV or in the movies. So now the first one was objection to form. The second was objection relevance. Igor, nice to see you. Thank you for joining me. The third one that I'm talking about now is objection hearsay. So, talking about a hearsay objection. What is hearsay? So now, thank you so much for those thumbs up. So now you're up on the witness stand and you want to tell the jury about a conversation that you had with one of the doctors in the hospital. And now, I'm not going to bring in that doctor to testify, and the defense attorney isn't going to bring in that doctor to testify, but yet you want to say something about what that doctor told you. So now I'm asking you a series of questions saying, hey, Mr. Jones, did you talk to Dr. Gold, who works in the hospital? And you say, of course. Tell us what he said to you. Now the defense attorney jumps up out of his seat, as if somebody pushed an ejection button. He jumps up, he yells out, objection, Judge, that's hearsay. And you know what? He's absolutely right. That is hearsay. And what does that mean? It means you want to go ahead and tell the jury about a conversation that you had. Obviously, the information in that conversation is going to be favorable to you. And we know it, and everybody else will know it. But can you talk about the details of that conversation? The answer is no, you can't. You want to know why not? It's because the defense has no way of validating or justifying whether or not what you are saying is true. Don't forget to tune in to Dave at 3 p.m. Yes, I will, Steve. Thank you. I know he's got a show coming up, and I'll be done in just a few moments. So the question is, how can the defense validate what it is that you are saying? How does he know if it's true if he doesn't have an opportunity to question him or cross-examine him? How does the judge know that what you are saying is true? How does the jury know? So what you are trying to do is you're trying to tell the jury about a conversation that that you had with this doctor. And now he says, objection, that's hearsay. So you are not permitted to tell the jury about the details of that conversation. You can talk about your own personal observations. You can talk about things that you said to the doctor, but not things that he said to you. Now, if we were going to call in that witness to testify, or if they were going to call in that witness, then yes, we could talk about that conversation. You could tell the jury about all the details that occurred. But otherwise, the judge would be fully within his right to turn around and say, Counselor, objection sustained. Unless you're going to bring in that doctor to talk about what that conversation was, you can't talk about it. That would be improper. So, we've talked now about 3 different common objections that we hear in a trial, whether it's criminal or civil. The first one was, objection to form, Judge. The second was, objection, that's irrelevant. The third one, which we just talked about, was, objection, that's hearsay. So why is it important for you to understand these objections? Well, first of all, it's important for you to understand if you watch any type of TV or in the movies and you hear about this courtroom drama, or you happen to be a litigant. Either way, I hope this information has been helpful. I hope it's been useful. And if you find it to be useful and have questions about your matter that happened here in New York, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. Have a wonderful day. Bye-bye, everybody.
Good time. Good time.